Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm reviewing a special book. It's one that I used as a student when I was on the bar course all those years ago now, and it wasn't called that then, it was called something else. I'll tell you about that in a minute. It's now known as O'Hare and Browne. It's called Civil Litigation, now in an 18th edition. It's been written by John O'Hare and Kevin Browne. It comes to us from Sweet Maxwell and THOMSON REUTERS, and it's a very important book. And I have to say, like many people, probably didn't value it the way I should have done when I first got hold of it as a law student. However, I've been very pleased to review this new edition because I haven't seen it for some time, and obviously things have changed dramatically from the time I was a bar student when we didn't have the civil procedure rules. It was a different system entirely. The book was a different format slightly then, and it was written by O'Hare and Hill in those days. But I do think the book we have today is a really excellent manual, and therefore Elizabeth and I have given a title for our book review: The Best Short Explanatory Guide to Current Civil Litigation in England and Wales. And that's exactly what you're getting with this book. Let me show it to you first of all. Here it is. This colour this year, I can't remember, I think blue was the colour I had. There's when I was looking at it years ago. There's the spine, and on the back you've got some basic detail about it all. And civil litigation, of course, is an important, very important area of law. It runs to 700 odd pages. The index, which is at the back, is by paragraph numbering. Very much the house style of Sweet and Maxwell, and of course they have their legal taxonomy mentioned at the beginning. The book has been prepared under the Sweet and Maxwell's legal taxonomy, and that explains how they structure what they include in the index. But you should find things very easily. You can see here, right at the back, these are appeals. Appeals are always at the back, I don't know why, but that's the way it is. You can see the paragraph numbering at the side there. Then you're just running all the way through. There's a huge amount of information. Lots of cases, of course. We go to the front. I've actually been using this quite recently, which is why it's a bit thumbed through already. There's the front page, and you can see the detail about the two people who are the authors, John O'Hare and Kevin Browne. And obviously from that we move on. There's the detail of the book. There's a paperback, then there's a preface. Preface is very well worth reading because they've included all the new stuff. Mitchell is there, the case Mitchell, and of course Civil Procedure Rules Committee is mentioned, and the preface, although it's relatively short, is as at, the law is as at stated, the 1st of September 2017. Then you get the table of contents running all the way through. Civil litigation in outline, so it explains everything. And in this day and age, I think it's a very good book for everybody to have a look at. You can see running through a lot of chapters covering every single aspect of what's in the white book. I'm going to get on to that in a minute. Table of cases, there we go, a lot of them. And after that, because there have been lots of case law, which I have featured in occasionally. Tables of statutes, there again. Then after that, a table of statutory instruments, then tables of civil procedure rules, very important of course. Again, as I say, very new in comparison with what I used to use, which was of course the white book and the green book, in a rather different way, because the two jurisdictions, rules of the Supreme Court and the County Court rules, were separate in those days. Then you've got the practice directions and protocols. Again, very important, must know your way around all of that. Then you get to chapter 1. You've got the paragraph numbering, the civil courts, the structure, the Supreme Court of the United Kingdom, the High Court, and where we are at the moment. There are changes taking place, of course. They've included the Patents Court and the Intellectual Property Enterprise Court and so forth. And then you've got, you run through and you can see the detail immediately. I think the most important thing about this book, apart from anything else, is it's incredibly practical. And I think even if you have been around a while now within the legal system, as I have as an advocate, you will find this book very helpful, because there are always going to be holes in one's knowledge. It doesn't matter which area of the civil procedure rules or the PDs or whatever it might be you're looking for, you're always going to have a need for something which will be a quick ready reckoner, if you like. And that is actually what you get, because the White Book, which is just there, which of course is the book I use in the County Court and the High Court, is the basic Bible. There isn't anything better than that. It's very difficult for me to say this because obviously there are competitors, but the White Book is really the fount of the knowledge, because that's what the judges expect you to know about. And I've found judges to be extremely helpful. If I haven't got my White Book with me in court, they will normally let me borrow one if I need to look anything up, and give me the time to do so, which I think is very helpful, because whilst the White Book's online, that may be helpful. For some of us, I haven't found it particularly helpful. It's useful to download things and look at things, but you can't cross-refer the way you might want to between PDs and the 2 volumes and various other things. So you do need the book as well. Now, what do we then therefore say about this book, which is the Civil Litigation Guide, as opposed to the White Book itself? Because the White Book itself, when I did the bar course, I hardly could make head nor tail of a lot of what was in it, and I'm sure a lot of other people had the same problem. And what was then O'Hare and Hill was a great lifesaver then. Now O'Hare and Browne, as it now is, to my mind, is continuing the really good work to try and unravel the problems that we have in trying to understand the civil litigation system. Now I say that because we are in an era now of litigants in person, and a lot of them do an awful lot of things which could quite easily be remedied by way of mistakes and errors, which cause a huge amount of difficulty when dealing with HM Court and Tribunal Service, who of course are not there to give legal advice, but are there just to effectively try and oversee things. They've got a very difficult role to play. I'd like to see them being in a position where they could give limited amounts of procedural advice, which of course would save a massive amount of time with some of the litigation, but that's in the future and a bit of a pipe dream. So what do we say? This book remains one of the most important texts for law students studying civil litigation. It's been completely revised to reflect where we stand today when dealing with proceedings, without a main reference to the White Book or its equivalents. In other words, you can use this as a standalone. You are eventually going to have to use the White Book if you're writing an opinion or you're going to be referring to something in court. But this is the first stop if you are a bit pressed for time, as I have been. I found it useful just to refresh my memories to some aspects of what I'm looking for before I go with the heavy mob, which is the White Book there. So you no doubt know a good number of civil practitioners who've used O'Hare and Browne Civil Litigation recently. The fact that it's been published annually and is now available from Sweet Maxwell, THOMSON, REUTERS in a new 18th edition attests to its consistent authority and reliability, and therefore its popularity. And as I've said, it has a much wider applicability than just merely to practitioners, in my opinion, because it's actually easy to read. Once you understand the system, you can actually take parts of it out and show it to the client and explain to the client what we're doing, because many of them are quite interested to know. And of course, there is a huge mystique. When I first studied law in 1970, the mystique surrounding the bar and solicitors and what was being done was really something, and it hasn't really changed that much. It's obviously we're much better informed members of the public today than we were, but however, in this day and age there are lots of unrepresented parties, litigants in person, and I think this book will help them. Effectively then, it's a primer for the White Book. I mean, that's what I'm saying, and Elizabeth and I talked about it, and that's how we've done the review. But it is a primer, or to give it its proper title, Civil Procedure. That's the White Book. The 2-volume practitioner work, which is also published by Sweet and Maxwell, these two here, plus the bits that go with it. Now, the point I'm making is that you've got to lug it's a huge 2-set volume to lug around. And so if you're actually in a hurry, certainly the Civil Litigation by O'Hare and Browne is a book which is there very quickly for one to use. And like the civil procedure rules themselves, O'Hare and Browne, as well as the White Book, are now obviously 18 years old and completely up to date, because the whole system has changed since I first started doing this some decades ago. Now, in its early days, O'Hare and Browne, or O'Hare and Hill, as it was then known, was designed mainly for postgraduate law students studying for a professional qualification, many of whom, like me, retain fond memories of this volume as a very useful source of guidance for the then new civil procedure rules and those dreadful multiple choice tests, which I never really liked at all. I don't think they help that much, but that was the way they do things. So be it, but I don't think it's the way to teach. However, that's the way we have the system, and you have to know your way around the procedural rules. Now, since that time, of course, and we're going back a long time for the change, its original complexities, of course, within CPR have been ironed out and simplified so that now it's accessible to a much wider readership, which fortunately, as times demand, includes unrepresented litigants as well as lawyers themselves. Of course, some of this information is readily available now on the web, although it's still very complex and getting more complex as the days grow longer. Now, with its clear explanatory title, civil litigation certainly helps lawyers who find themselves having to explain convincingly the specifics of the CPR to clients, especially those who are argumentative. And let's not forget that the original purpose of the CPR was, and still is, in the words of the authors, to make the civil justice system accessible, fair and efficient. Basic mission, using modern language that was both simple and simply expressed. Now again, that is where we have moved to, and as I've said before, the system isn't perfect, but I think it's a tremendous step forward from what were certainly very, very difficult rules prior to the introduction of the CPR. And so I'm grateful that we have this book to assist us today, because I, like many other people, had a lot of problems with the older system, and we do have a much more streamlined system today, which I think is much straighter. It's actually fairer and it's easier to understand, even though it's incredibly complicated. Now, the authors are quick to point out in the preface, however, that the noble aims of simplifying the law have not been entirely achieved, and sure Lord Wolfe would agree with that, because what he came up with was wonderful, but look what we've got today. It's getting bigger and bigger all the time. Two examples are mentioned, one of them judicial review, the other part 36 offers to settle. Now, the authors nonetheless paid tribute to the CPR, calling it a massive success, it certainly was, and to the work of the CPRC, the Civil Procedure Rules Committee, and that's mentioned right at the beginning of this work. Now, the CPR is credited with demystifying civil procedure and has encouraged parties to make huge savings in time and expense, absolutely, whilst continuing to search for further improvements and simplification. And they say that, and I say that, although I just wondered whether we've actually got the simplification we wanted, because it does seem to me to be more complex. But that's partly to do with practice guidance and so forth. Now, bearing all this in mind, the stated aim of demystification, which is in this book, O'Hare and Browne, will continue to endear itself to virtually all civil practitioners, and that includes solicitors, of course, as well as counsel, particularly at the initial stages of their careers. Now, whatever your career is taking you, you'll appreciate the considerable amount of new material contained in this new edition to update yourself. To cite only a few examples, coverage includes the following: redacted documents, big issue at the moment, surveillance evidence, the format of an electronic bill, annulment of bankruptcy orders, and hot tubbing the evidence of expert witnesses. Always an interesting area. Indeed, the latest O'Hare and Browne edition is completely contemporary with the latest case law, legislation and CPR developments. So from pre-action to enforcement and appeals, all stages of litigation are here included. And that's why, although it can't go into the detail of the White Book, obviously, you are getting a first-class service here to point you in the direction. Then you have to go to the 2 volumes of the White Book to actually find what you need if you're going to make a submission to a judge. Now, let me conclude by saying, in the over 700 pages this book has, the edition combines logical structure and ease of use with a wealth of research resources, including tables of cases, statutes, statutory instruments, CPR, and a table of practice directions and protocols, which are very important, of course. And on its own, or as a supplement to the White Book, we think this book is indispensable. And frankly, I do think you should have it in practice today, because it does actually save time. The book was published, this one, the edition, on the 24th of October 2017, and as I said, and it's indicated by the two authors, the law is as stated effectively as they can do on the 1st of September 2017, and I'm recording this at the beginning of 2018. There's the book again, there's the spine, and then there's the back. You see there's some detail on the back. Just run it up a bit and you can see there's detail on the back there. Just opening it in the middle, I used it the other day. This is directions on allocation. This is to the various trackings. Very helpful, a lot of information. I do say this is expert, again we've got expert evidence covered there. The hearing of the claim, appeals and so forth. This is all the small claims track we're looking at here, part 27. Now, as I've said before, to a lot of people this will initially be very, very confusing, but very quickly, I have found this, very quickly people pick it up, including litigants in person, where money is tight and they need something like this. Now, this book is not an expensive book. The White Book, of course, is, but the point I am making from the point of view of O'Hare and Browne is that if you have got, for instance, as I do, direct access work, quite often it might be worth telling the client to get a hold of this book if they're going to be doing quite a lot of the work initially themselves, because I don't do litigation. It may well be useful for them, if they feel comfortable with it, to actually go for this book initially, because they're not going to fork out 700 quid for the White Book, when in fact this may well assist them, and then they come to me and I will give them the general service that they need for the advocacy within the court structure itself. But I think that's one of the ways forward. I can't thank these people enough, because this is, as I said before, this is a lifesaver. It's also something that's so very fundamental to my practice as a barrister at law in the civil justice jurisdiction. So can I thank you all very much indeed for what you've done, and you do make my life a lot easier. Thank you. Bye-bye.